Is that son of yours a thief? If you gave your daughter $50,000 in a way only she could get it, with the promise that she gives 75% of it away to her siblings, but you both know there's no way you'll ever be able to verify she actually did it, would you trust your brother to give you that money? Your cousin? Your uncle? Today we're tackling a surprisingly common estate planning mistake, one that almost guarantees family drama, tears, and possibly some lawsuits. Here's the scenario. You think leaving an asset like a bank account, life insurance policy, or retirement fund directly to one child as the designated beneficiary will make things easier. But in reality, you're setting the stage for legal chaos and ensuring your family won't be speaking to each other after your funeral. Sound familiar? Stick around and I'll explain why you should think twice before naming someone other than your trust as the beneficiary. Trust me, this is advice you don't want to ignore. Here's something many people don't realize. Assets with designated beneficiaries like bank accounts, life insurances, or retirement accounts pass outside of probate and your trust. That means they go directly to the person you've named as the beneficiary, completely bypassing your will or trust. So even if your estate plan says all assets to be divided equally among my children, it doesn't matter. If you've named one child as the beneficiary, the law says that asset belongs solely to them. They have no legal obligation to share it with anyone else, no matter what promises they've made to you or what your intentions were. Let's talk about one of the biggest myths in estate planning, verbal promises. Imagine this. You tell one of your kids, hey, I'm leaving you as the beneficiary on the account, but I expect you to share it with your siblings. Sounds reasonable, right? Well, legally, it's meaningless. Unless there's an explicit written agreement, and I mean legally enforceable, not just something scribbled down on a napkin, that child can do whatever they want with the money. And if they decide to keep it all, well, that's perfectly within their rights. In fact, I've seen this exact scenario play out in real life. A parent leaves a savings account and life insurance policy to one child, expecting them to turn the money over to the trust. Instead, that child just keeps the money, and suddenly the siblings were all at war. Nobody wins except maybe the attorneys, so thank you very much for the business. But in this real-life case, there was nothing we can do. Mom created a trust and had 4 assets: a house, a checking account, a savings account, and a life insurance policy. A couple of years after creating the trust, Mom set one of her 6 children as the designated beneficiary of her savings account and life insurance. About $150,000 to $200,000 in total. Many of the siblings apparently knew this, but when it came time to ask for the money, the one designated to receive it decided to just keep it all to herself. Short of being able to show some sort of undue influence, coercion, or duress, that's it. End of story, book's closed. Money is hers. There were 2 kickers to the top of this case too. Firstly, mother left the money to a child that was not named in any position of authority in mom's trust or powers of attorney. Said in another way, mom apparently trusted one child enough to share money after her death, but didn't trust that daughter enough to let her help manage the money while mom was alive, or to put that child in charge of taking care of the house after mom's death. Curious, but okay. Next, however, mom's trust specified that some of the money from her savings account in particular was to go to another child who needed extra financial help. Why would mom be that specific in her trust yet give that money away to another child a couple years later? I don't know. Curious again, though, but okay. Now, instead of honoring their mother's wishes, the family is locked in a bitter dispute. All because mom thought naming a beneficiary would apparently make things easier. Spoiler, it didn't, and now nobody's going to talk to that sibling after the money from the house is distributed. So, how do you avoid this nightmare? Simple. Make your trust the designated beneficiary. When you name the trust as the beneficiary, the funds become part of the trust and are distributed according to its terms. You ensure that your children, or whoever you've named as the beneficiaries, receive their fair share, and you avoid putting anyone in the awkward position of being the middleman, or worse, the villain. This is especially important if you've included specific conditions in your trust, like providing for underage beneficiaries, supporting someone with special needs, or just setting aside funds for public benefit eligibility. Let me make one thing clear. If you've gone to the trouble of creating a trust, don't undermine it by leaving assets outside of it. Every time someone tries to make things easier by naming a direct beneficiary, they almost always make things harder, or at the very least, much more expensive. And here's a quick warning: never, ever think that a handwritten note on your trust will be considered as a valid amendment. Trust law doesn't work like that, and if you think otherwise, go watch my video on handwritten amendments. I'll link it here, but let's just say you'll want to get a professional involved before scribbling anything down on your documents. Estate planning is about ensuring your wishes are carried out and minimizing family conflict after you're gone. The best way to do that, well, you keep your trust up to date and designate it as the beneficiary for your accounts and policies. Trust me, your family will thank you for it, or at least they'll have one less thing to fight about on holiday dinners. But let me know, have you seen situations where a beneficiary refused to honor someone's wishes? Drop your stories in the comments below. I'd love to hear them. And as always, like, subscribe, share this video with anyone who wants to make things easier. I'm attorney Andrew Bethel, and I'll see you at our next meeting.